Imagine a huge soccer match. The World Cup final. The game is tied. It goes to a penalty shootout. The last shot is taken, the crowd goes wild, but, wait. One team says the goalie moved off the line too early. Suddenly, the game isn't over. Everyone turns to a person in a booth, watching a replay. This person, the video assistant referee, has to make the final call. That one decision decides the champion. Now imagine that soccer match is an entire country's election, and the referee is a judge in a long robe. This is what happens when courts get involved in choosing a president. It's a massive responsibility, and if people don't trust the referee, they won't trust the outcome. It can get messy, fast. This whole process is called judicial review of elections. It's a powerful tool designed to make sure elections are fair and follow the rules. But it's also a political minefield. Judges, who are supposed to be above the political fray, are dragged right into the heart of it. This essay will look at this exact situation. We'll use a specific, high-stakes example: the 2012 presidential election in Ghana. A country often praised for its democracy found itself in a tense standoff where the Supreme Court had the final say. We will explore how this case became a critical test for Ghana's democracy. So, what exactly is this judicial review thing? Think of it like a rule book for the government. In any country with a constitution, that document is the ultimate rule book. It lays out what the government can do and what the government cannot do. Judicial review is the power of the courts, usually the highest court in the land, to look at an action taken by the government, a new law from Parliament or a decision by the President, and check if it follows the rule book. If the action breaks the rules of the Constitution, the court can blow the whistle and say, "Nope, that's out of bounds." It's a fundamental check on power, ensuring that nobody, not even the most powerful politician, is above the law. When it comes to elections, this power becomes incredibly important. An election is the process of choosing leaders, and that process has rules. The Constitution and other election laws define how votes are cast, how they are counted, and how a winner is declared. After an election, if one of the candidates believes the rules were broken, they can't just declare themselves the winner. They file a petition, and the court investigates and decides if the election was fair and legal. Let's set the scene. December 2012, Ghana. The country had just held a presidential election. The Electoral Commission declared the incumbent the winner, John Dramani Mahama. National Democratic Congress. It was a close race, very close. The main opposition leader, Nana Akufo-Addo, was furious. New Patriotic Party. They claimed there were serious problems with voting and counting. They alleged irregularities, violations of the rules, outright malpractice that unfairly tilted the result toward Mahama. Instead of protests in the streets, they went to the Supreme Court. A landmark moment for Ghana and African democracy. For 8 long months, the nation was captivated. Proceedings were broadcast live on TV and radio, like a legal Super Bowl. People in offices, markets, homes were glued to their screens. Lawyers argued over pink sheets, the official result forms, over voting without biometric verification. The petitioners asked to annul millions of votes, enough to flip the result. The respondents, President Mahama and the Electoral Commission, argued mistakes were minor and didn't change the outcome. The tension was palpable. The case rested on a panel of 9 Supreme Court justices. Every word they said was scrutinized. Past rulings were dug up. Personal lives speculated. PR wars, NDC, NPP, flooded the airwaves. Finally, in August 2013, the verdict came. By a 5-4 majority, the court dismissed the petition and upheld Mahama's victory. Akufo-Addo accepted the verdict and urged calm, a move widely praised that pulled the country back from the brink. So, who are these powerful people in robes, and how do they get their jobs? Understanding this is crucial because selection shapes independence. In Ghana, appointments to senior courts are political processes. The president is the main player, with power to nominate Supreme Court justices. Nominations are made on the advice of the Judicial Council. Judges, lawyers, legal experts tasked to safeguard independence. The President also consults the Council of State. Finally, Parliament vets and approves nominees. On paper, multiple checks provide oversight. In practice, the President influences key bodies, especially the Council of State, weakening the independence of advice. Then, in big cases, the Chief Justice impanels which justices hear the matter, a subtle but powerful lever. In the 2012 petition, picking the 9-judge panel was itself a consequential decision. When one person can select the referees, perception of neutrality is at risk. The judiciary's path is intertwined with politics and must be managed transparently. When presidents shape courts, perceptions of loyalty can overshadow merit. Suspicion erodes trust, especially in election cases. People start predicting outcomes by who appointed whom, not by law. The temptation to pack courts turns justice into politics. When faith in courts fades, instability follows. In 2012, commentary fixated on appointment histories, a warning sign. How judges think, the 3 secret playbooks. Legal model. Judges apply text, statutes, precedent, and facts neutrally. The law is the law. Example. If verification is mandatory and not done, those votes are invalid. Full stop. Attitudinal model. Judges are human. Ideology and preferences can drive outcomes. Strategic model. Judges weigh legitimacy, backlash, and institutional limits to craft viable rulings. They may moderate positions to secure a majority and protect the court's authority. A judge might fear chaos or defiance, so upholds the result but writes a stern warning for future elections. In Ghana, all 3 models appeared to shape the journey to a fragile consensus. Strategy can preserve peace while signaling reforms, if communicated clearly. The trick is balancing law, legitimacy, and democracy's will. The peaceful 2012 resolution was a victory for the rule of law. Politics went to court, not the streets, and leaders accepted the verdict. But the case exposed messy, subjective interpretation and concerns about independence. The court upheld the result, yet criticized the Electoral Commission, creating a mandate for reform. Reforms followed: better registers, standardized pink sheets, stronger training. New precedent clarified what counts as a valid vote and when annulment is warranted. Simple steps: transparent, merit-based appointments, truly independent advisory bodies, fair, transparent empanelment, plain language judgment, summaries the public can trust. Fair courts make strong democracies and help the country move forward in peace.